Hello everybody, hola. It's great to be in Latin America even though through a video conference. Firstly, let me apologize for not being able to attend your important international conference on the politics of access to medicines and human rights 2016 in person due to prior commitments. I hope all of you have a great and a fruitful conference. I would like to thank the organizers of this conference and a lot of my friends in Brazil for giving me this opportunity to address all of you and this distinguished gathering. As you know, access to essential medicines is an integral component of the right to health and has been specifically enunciated under a number of international instruments, including the International Covenant on Economic, Social and Cultural Rights. Article 12 of the ICSR provides for the right of everyone to the highest attainable standard of physical and mental health. States have an obligation to respect, that is not to interfere with the right itself, protect, that is prevent interference by others, and fulfill, take all administrative measures for the right to health. This right is elaborated by the Committee on Economic, Social and Cultural Rights in General Comment number 14. General Comment 14 provides that all health services, goods and facilities, including medicines, are to be made available, accessible, acceptable and of good quality. Furthermore, the provision of essential medicines to all persons has to be in a non-discriminatory manner, which is a core obligation on the state, which would also include ensuring availability and access to quality, affordable medicines. Latin American countries, being civil law countries, have an advantage, as any international human rights treaty that has been signed and ratified becomes domestic law, unlike in common law countries like India, which need to domesticate the treaty into domestic law in compliance of the international treaty. The role of law in saving lives is evident from the time HIV was wreaking havoc all over the world. The mid-90s saw the advent of triple combination antiretroviral therapy, ART, which became available in the West immediately, while millions of people living with HIV in the developing world could not access ART even in 2000. During this time, drugs were priced at about $10,000 per patient annually, directly denying access to life-saving ART to people living with HIV in poorer developing countries. It was only when developing countries like Brazil took the initiative to provide better health care did the movement to make ART more accessible in developing countries began. When Indian generics announced that they would provide ART at $350 per patient, accessibility of ARTs became more possible. The resulting increasing level of competition in the generic market thereon led to a 99% drop in the price of ARV drugs from 2000 to 2010, providing access to medicines to millions of people across the world. Indian generic companies were able to sell ARVs at these prices because the Indian patent law at the time did not recognize patents on pharmaceutical products. Before 1972, the original British Patents Act in India of 1911 allowed patent protection for both products and processes, allowing the patent holder to exercise absolute monopoly rights and control on both, and thereby the availability and price of a drug. The consequence of the 1911 British Act in India was that drug prices were the highest in the world. Realizing the need to prioritize public health as a priority, the patent law was amended in India in 1970. Protection only for process patents was allowed and no protection for product patents was granted. This simple measure allowed competition to flourish, and by the 1990s, Indian generic industry became the pharmacy of the developing world, offering lowest medicine prices. Thus, by the late 1990s, nearly 90% of the ARVs in the developing world were provided by the Indian generics. While all Latin American countries do not allow an identical system of providing affordable medicines, in spirit they are trying to enforce a system that follows the principle of access, affordability, availability, and quality of medicines. While in Brazil, the development of public health policy was intertwined with intellectual property legislation, Chile has been battling HIV/AIDS by focusing on healthcare reforms and promoting competition within its pharmaceutical sector to decrease medicine prices. The access to medicines, however, is gravely affected in situations of emergency, as is the case of Venezuela, where the government decreed a state of exception and economic emergency. The attempt to make medicines available through a legislation allowing medical help through foreign channels did not see the light of the day when Venezuelan Supreme Court ruled that such a law violated their constitution. In the early days of the fight for access to medicines, Brazil had a major role to play. The 1996 policy of the Brazilian government to provide free ART to PLHIVs was instrumental in improving health and providing access to medicines to thousands of Brazilians. This was possible partly because of the expertise of Brazil's domestic pharmaceutical industry, which allowed the country to produce generic versions of antiretroviral drugs. Thus, Brazil provided a shining example to the rest of the developing world. I regret to say that unlike Brazil, though India had many generic companies, free ARV support for people living with HIV in India, like Brazil, was introduced in India only in 2004, almost 10 years after its introduction in Brazil. At the global platform, the Brazilian policy of free access to ART was regularly used as an example to demonstrate that the goal of access to medicines is achievable. The 3x5 initiative from the WHO, implemented in 2003, is one such instance. In fact, the Doha Declaration, which emphasized on TRIPS flexibility for better access to medicines, is often seen as an acknowledgement of the Brazil's policy for free ARTs. Because of Brazil, the rest of the developing world started free ART programs thanks to the likes of the Global Fund on HIV, TB and Malaria, PEPFAR and UN-AIDS. While protection of product patent could be excluded earlier, the TRIPS agreement changed all that. Under its protection had to be provided to both product and process patents. India and the developing countries agreed to the TRIPS agreement because of the flexibilities that could be used in their domestic IP laws. The flexibilities enshrined in the TRIPS agreement were fought for on the basis of public health interests. These flexibilities aid the objective of making medicines available at affordable prices. These include allowing members to define their own patentability standards, provide compulsory licensing safeguards, and opportunities to challenge patent applications, amongst others. Exercising this flexibility provided under TRIPS, in 2005, India amended its patent law and added higher standard of patentability in its patent law to address the evergreening of patents and inserted Section 3D in the Indian Patents Act. Section 3D does not allow patents on new form of known substances unless there is significantly more efficacy over the known substance. Section 3D was crafted based on the experience in the US and the EU, where over 76% of the pharmaceutical patents were new forms without giving any additional therapeutic benefit. This provision was challenged by Novartis in India when its patent application on the cancer drug Gleevec was rejected. Novartis claimed that Section 3D violated the TRIPS agreement and the constitutional equality provision. Section 3D was upheld by the Supreme Court of India, amongst other grounds, as a fulfillment of the right to health obligations of the Government of India. Section 3D is crucial to promoting generic competition and reducing the prices of costly drugs which have exceeded their patent period. However, developing countries and powerful multinational corporations bloc such as big pharma are increasingly focusing on furthering their narrow industry agenda of super profits, forcing developing countries to do away with their laws which ensure access to affordable medicines. India, for example, is facing immense pressure from the US to dilute Section 3D of the Patents Act. The pressure is also not to allow countries to introduce provisions similar to Section 3D in their patent laws. I am of the view that more and more developing countries should adopt provisions similar to Section 3D. The pressure is also not to allow local manufacturing in developing countries. Access to medicines has been determined by local manufacturing capacity of states. Sadly, there are a limited number of developing countries capable of manufacturing drugs locally. Local production must be encouraged as a long-term investment in the security of access to medicines. This involves states considering statutory and policy measures which create an enabling environment for local producers to promote the growth of the pharmaceutical industry. Today, access to affordable medicines is under threat in a variety of fronts. The primary danger, as always, is the pressure that the US and the EU are exerting on developing countries to dilute their IPR regimes through threats of trade sanctions such as US 301 and free trade agreements like NAFTA that had a devastating effect on Mexico. Negotiations in large multi-trade deals like the Trans-Pacific Partnership Agreement and the Transatlantic Trade and Investment Partnership Agreement indicates the aggressive stance of the US, which is pushing for TRIPS plus standards of patent protection. This will destroy any tools for making medicines affordable. The latest tool of big pharma companies is the use of voluntary licenses granted to the generic players in developing countries, thereby influencing accessibility and affordability of medicines. Because of this, the generic companies are not filing patent oppositions or demanding compulsory licensing. For example, in the case of sofosbuvir, a hepatitis C drug, in India, the generic companies withdrew their patent oppositions and did not even demand a compulsory license because of the voluntary license given to them by Gilead. Though countries like Latin America and MENA are most in need of drugs like sofosbuvir, they have not been included in the list of countries to which Indian generic companies can export the drug under the voluntary license. In my view, voluntary licenses have passed on the initiative from the state to the private sector and have put multinational corporations in the driver's seat to control the accessibility and affordability of medicines. Though this challenge is to be met internationally, unfortunately, civil society organizations which were united at the turn of the century are now divided over voluntary licenses. I would like to conclude by saying that the framework on the right to health makes it clear that medicines must be available, accessible, acceptable, and of good quality, and reach the ailing populations without discrimination throughout the world. Affordable access to medicines cannot be achieved sustainably without sufficient market competition. The need of the hour is for developing countries to utilize and preserve the flexibilities embodied in the TRIPS agreement in their national laws and prioritize the right to health above all, and this includes rejecting free trade agreements. For this, civil society again needs to be united across the continents, from Latin America to Europe. Africa and Asia to challenge the agenda of multinational corporations on free trade agreements and bilateral investment agreements, as well as the voluntary licensing regime through a consultative process and timely intervention. This is required so that the state can be back in the driver's seat to make medicines accessible and affordable for its own people. I hope this conference works towards this objective. Finally, I thank all of you for your attention, and I hope that the recommendations derived from this conference will be of benefit to the people living with ailments across the globe. Thank you very much.